People v. Robinson.
Good afternoon, Your Honors. May it please the Court. Cara Labini for Appellant Savion Robinson. I'd like to reserve 2 minutes for rebuttal, please.
Sure.
Thank you. Although 2.5 sounded good, too. The respondent here agrees that the tests governing custodial interrogation are from Cabrera and from Innis, yet the lower courts here applied neither. The test for custody under Cabrera is whether a reasonable innocent person would feel free to leave and whether his freedom of action has been constrained to the degree associated with a formal arrest.
So if you accept that the person is in custody, is there such thing as an investigatory exception to Miranda?
The test for interrogation, Your Honor, comes from Innis, and it's whether the police should know that their questions are reasonably likely to elicit an incriminating response.
But what do you think the line is between the public safety exception articulated in Quarles and what you and I think the amicus briefs suggest are investigatory questioning exception cases in the lower courts? Where do we draw that line? Because I assume I don't take you to be challenging Huffman itself, and I don't. Obviously, Quarles is what it is. So where's that line?
So to be clear, to back up one step, this court need only address whether the lower courts applied the correct standard, whether there was any record support for their findings, and harmless error to dispose of this case.
But to the extent that whatever we might say would shed some light on future cases, what's the line between a public safety exception and what you point to in the lower courts? I think note 7 in your brief, I think the amicus brief points to some cases as well.
Right, so to the extent that this court is interested in giving much needed guidance to the lower courts on an issue of fundamental constitutional law, there's 2 things that I would like this court to focus on. One, to Your Honor's point, there is no such thing as an investigatory questions exception.
But you seem to take Huffman as good law, and there is some effort to ascertain in the moment what's happening, what are the people in the bushes doing, what's the fellow who's actually at his own home doing, and I take it you're not suggesting that's impermissible. So what's the line between that and investigatory questioning? That's what I'm
Well, our position is that the test that Huffman uses, which it states at 33, statements are suppressible only if there was a process of interrogation designed to elicit statements from the defendant. So to the extent that Huffman stands for that rule or applies that rule is clearly overruled by Muniz and Innis, which this court should clarify.
Wait, so you think Huffman is no longer viable?
The test that Huffman uses is clearly overruled by Muniz and Innis because it focuses on the purpose.
Well, so then how do you think the facts in Huffman would come out then under current law?
Sure, under Innis. So the Innis test is whether the question would be reasonably likely to elicit an incriminating response.
And so what are you doing back here was the question.
Sure. What that question reasonably elicits is, I'm running away from the police, or I'm running away from you. Not necessarily the incriminating response that was elicited, and Innis does not require the police to expect some sort of non-responsive, surprising response from the defendant.
Oh, well, you mean the surprise is the defendant actually answered truthfully?
Yes, or said, we were trying to break into that deli, which was not really responsive to what are you doing behind that bush.
Just so I'm clear, do you think
they answered with an inculpatory statement as opposed to something perhaps more innocuous?
Sure, and the question was very limited to the person's location and the reason for it, not what were you doing behind that.
But so I'm clear, do you think that the question asked in Huffman was interrogation under Innis?
No, because the question asked, what are you doing back there, was not reasonably likely.
So Huffman stands on its facts, you're agreeing, yes?
If you take all the facts in Huffman and apply the Innis test, yes,
So it's the test that was articulated in Huffman that no longer survives Innis.
Exactly, Your Honor.
Or current application of the interpretation of that test?
I'm sorry?
Current application by the courts of the interpretation of that test. if I'm understanding.
Right, I mean, the way that the court looked at all of the facts, the
Yes.
relevant facts, was guided by the test. Courts, given the same facts, might look at them slightly different when the test guides examination of facts differently.
Can I
So-
ask you said there were two things you wanted us to keep in mind. This was the first. What's the second?
So the first is that there's no such thing as an investigatory questioning exception. And the second is that, as I said, the rule that Huffman advances or relies on, which it cites as People versus Serrato, a pre-Huffman case, which is also pre-Innis, of course, which focuses on the purpose of the questions, was overruled by Muniz and Innis. And the reason for that is because the purpose of the officer in asking the questions is not the focus. The focus is the suspect's perceptions.
Yeah, I'd like to, following on that, can we talk a little bit about custody? Because we agree that custody is a person innocent of any crime would think that they were under arrest, right? Here, under these specific facts, they're in Times Square, a very busy place. This fight breaks out, or attempted robbery, or whatever it is. Lots of police officers around just by virtue of the fact that it's Times Square and there's tourists and so on. They're separated, both people get cuffed, both people are detained, both people are being spoken to by the police. So why is it that, or why isn't it that a person innocent of a crime might think, you know what, they're holding everybody here until they figure out what's going on? I don't think I'm under arrest.
So in this particular case, first of all, they applied handcuffs, which does indicate a
To
level
both.
Sorry?
To both,
Correct.
yeah.
In this particular case, the police asked Mr. Robinson, I saw what you did. Why did you go after him like that? They said,
So are you saying the police officer actually saw what was perceived to be a crime in progress?
yes, exactly, Your Honor. And then they pressed him even further.
But I'm talking about the custody part of this.
Yeah, right, but it's all relevant to whether, I mean, I suppose there is no person who the police tell, if the police officer says to the person in handcuffs, we just saw you commit a crime, there's no reasonable innocent person in that situation that would feel free to leave because the officer tells that person that they don't think they're innocent, that they're going to remain cuffed.
But the police did see him commit a crime apparently, and it's on video. So why isn't it harmless?
Yes, Your Honor. So the defense's theory at trial was that this was a larceny plus a retaliatory assault. The prosecution argued that this was a robbery, a forcible taking. So the question at trial was the purpose of the force. Was the force used to retain the bicycle, or was the force used in retaliation? Anyone committing a retaliatory assault would have quickly said, I punched him because he grabbed me or he jumped on me. The omission of that excuse clearly contributed to a finding that the force was used for the taking and not to retaliate,
I'm sorry,
especially,
I'm just not following that. So what was the statement that came in?
I punched him.
Okay? And how does that go to that issue you've just been talking about?
Because any fact finder that hears that without an explanation for the punch is predisposed, or certainly it contributes to the conviction or to the finding.
How does that explain the punch? If all he said was, I punched him.
Punches on the video.
Yes, but the explanation of why clearly contributed to the finding that the force was for the taking.
Because you're saying that when someone who is innocent says, I punched them, they would explain the innocent reason for punching them. As in, I
Yes.
punched him because he hit him, I punched him because he jumped me, right? Is that?
Exactly. And furthermore, the way that it came out at trial was very prejudicial, not through one police witness, but through two, the second of whom argued that this, or testified that this was a spontaneous utterance. So if the defendant just says, I punched him, that's clearly contributing to a finding that he's the aggressor, that it's not a retaliatory assault, which was the defense's position at trial. In general, confessions are powerful evidence of wrongdoing. They're straight from the horse's mouth, especially in a case, Your Honor, yes, there was video, but the video was blurry. It was from a distant vantage point. And slight movements are very difficult to make out from that distance. The slight movements that are the issue here, as to the purpose of the violence, were not visible on video at all, and so the statement was used to clarify the video. So there's more than a reasonable possibility that this contributed to the conviction when there was no explanation of what the force was used for.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the Court. Peter Rienzi on behalf of the people. This Court should affirm the defendant was not in custody, the brief investigatory seizure was not the equivalent of a formal arrest, and a reasonable, innocent person would have believed that he was being detained and handcuffed for a limited time while the officers investigated.
What was the total time of the seizure?
I'm sorry?
What was the duration of the seizure?
The seizure, so the statement came out around 8 minutes after the two men were handcuffed. After that point...
Which statement are you referring to?
Oh, I apologize.
I punched him out?
I just punched him. I punched him right out, exactly. The officers, as we say in our brief, asked no further questions after that and made a determination. It can be seen from the video that they conferred away from the two men, made a determination.
Still in cuffs, though, right?
I'm sorry?
Still cuffed?
Yes, absolutely, still cuffed, right. And then eventually, 7 or 8 minutes later, they let the other man, Mr. Boyd...
But
So
isn't cuffing, I already have a position on that, but let's go with where the majority has been on that. Cuffing with, as I recall, the officer then explaining, we're trying to figure this out, suggests that the point of figuring this out is there's going to be an arrest since these two are fighting in the middle of Times Square. Somebody's going to jail.
Your Honor, I don't think it is that clear that somebody's going to jail. There were not really visible injuries to either person.
Well, does it have to be a conclusion that necessarily somebody's going to jail for something to be a custodial interrogation?
No, Your Honor, I don't mean to misstate, but I'm saying that I don't think that the officers, there is reason to believe that the officers did not treat defendant, Mr. Robinson, as the perpetrator for the entirety of this time.
No, but they made clear nobody was leaving until they resolved it, right?
Yeah, yes, Your Honor, but that fulfills the freedom to leave question, not was the detention the equivalent of a formal arrest. So, in other words, a reasonable innocent person could have considered, obviously, the fact that they're handcuffed and that they're not free to leave at that point, but then all the other factors, including...
My point, and if you're handcuffed, since I don't
Yes.
believe they argued this was for public safety, although I could certainly understand that argument, you're in Times Square and these men are fighting quite aggressively, that much you can see from the video. I could certainly understand that argument, I don't recall it was made. In any event, the handcuffs are to ensure that there will be an arrest. It's very hard for me to kind of see this otherwise.
Your Honor,
We're going to figure this out, handcuffs, we're going
Can I ask
to
you?
decide.
You can answer.
Yeah, no.
So
Why
figuring
isn't
it
that-
out, I mean, figuring it out could refer, they did not say to either person that they're under arrest. As Judge Singas pointed out, both men were handcuffed. Both men are being asked these fact-gathering questions.
Could defendant hear, does the record reveal in any way, could defendant hear the complainant's allegations that defendant had taken the bike and then they got into this altercation?
I don't think that's clear, Your Honor. I think looking at the video, it seems like they might have been 15 feet away or so. So I'm not, there's obviously nothing in the record to indicate defendant hearing it.
That's what I wanted to ask you about, too. When is it in the interaction that Boyd says he stole my bike?
He says it a couple of times, Your Honor.
It's not very long into it that he makes that claim, right?
I believe, I think he makes it the first time, he makes it to a couple of different officers, Boyd.
And I'm wondering if, having said it potentially very early in the episode, and to several different people, whether that changes the nature of the custodies. Does it take it from investigatory in the sense of just trying to figure out what's going on to investigatory in the sense, I think you heard somewhere before, oh, we're investigating a pretty serious crime here. We might have a robbery on our hands or something like that.
It doesn't take it to that level automatically because the investigation is still going on. They are still, right before Officer Espinal asks defendant the what happened question, which yields the answer, I punched him right out. Officer Espinal, a minute or two before that, is speaking to Mr. Boyd, and Mr. Boyd is trying to explain what he said about defendant stole his bike, and defendant was hitting him, and he wasn't doing anything. And Officer Espinal wasn't really accepting it. I think that the officers were trying to get to the bottom of this by giving each person a chance to explain what was going on. I think because there was a fight, they wanted to hear from both of them, and they didn't want to just take Boyd's explanation and then say, okay, our investigation's over, and now we're going to arrest Mr.
No, I'm sure they weren't, because if they just took his explanation for it, there would have been some sort of immediate arrest, right? They would have
Yes,
taken him away.
exactly. They would have.
But now they're thinking there might be an arrest. There's been an allegation of a more serious crime being committed here than just some street scuffle where there were no injuries, as you said. So I'm just wondering if that is an indicator that we're not dealing with simply trying to calm a turbulent situation.
I think that they still were trying, I mean, obviously the situation, they acted to secure the situation. They asked these questions, they asked them both if they needed medical attention. They tried to see, do you guys know each other? What is the reason for this fight going on? They're still trying to gather the facts. I mean, it's a very fluid situation. It is in Times Square, in a crowded area. They are then.
Do you rely on the public safety exception specifically?
No, Your Honor, that was not relied on below. That has never been relied on by the respondents here.
Thanks.
Could you address harmless error?
Yes, absolutely. Here, it was harmless error, and the appellate division was correct to say so, because the evidence against defendant was overwhelming in this case. And I think, Judge Garcia, I think you said it, the punch, the aspect of the conduct that defendant admitted here, which was he punched him, that, because the video came into evidence, the surveillance video, that video showed that defendant punched Boyd 5 or 6 times is what it turned out. And the trial court asked to view that video multiple times.
Well, I think your adversary's point is not so much the fact of admitting a punch, it's the lack of explanation for the punch. Can you address that?
Yes. I believe that it's, I mean, first of all, I mean.
As I said before, I think her argument was any innocent person would, if the cops are asking and you're in handcuffs, would not simply say, I punched him, but say, I punched him because he punched me. But whatever might be what one would think would explain to an officer your conduct that is not conduct that's criminal, right? That is in self-defense or something else.
Right. I mean, the defense counsel did not, object to the introduction of any of this testimony, did not cross-examine either officer regarding the statement. Obviously, the defendant did not testify, as was his right. So there really was, other than the police testimony about it, there were no statements in evidence about anything other than what this statement was, that he punched him. I mean, and obviously the point I'm making about harmless error is that fact, that admission, was completely redundant to testimony about.
Did the prosecutor in any way argue this very issue about, if he was innocent, he would have said something?
No, that certainly, I mean, the statement was not mentioned in the people's summation. It really played a marginal role. Obviously,
the complainant says, I'm punched, you've got the video, right?
I'm sorry?
You've got the video, you've got the complainant.
Right, and the complainant
Not in
testimony.
dispute that there's a physical altercation between these two men.
I apologize, Your Honor, I
I'm
missed the
sorry, there's
beginning.
no dispute that there's a physical altercation between
No,
them.
it doesn't seem like it would be a fruitful thing to dispute. There is a video of the entire incident. You have Boyd's testimony, the victim, and then 2 officers who saw the tail end of the fight. So the admission was redundant to that evidence. Further, just to touch on.
What does
yes.
by force in robbery 3 require? Does it require a punch?
Does the force in robbery 3 require a punch?
Yeah. As a statutory matter, what's force?
I think force, the physical force, I mean, I think obviously a punch would fulfill it,
Right.
but would it be fulfilled, your question, would it be fulfilled with something less than a punch? Is that?
Like wrestling somebody or trying to throw them to the ground or scuffling with them where there's no punch thrown?
I think that it would be fulfilled by that. I think, obviously that was not, I don't think that was raised below. I think that I think what was raised below was the punch, and Boyd testified that defendant, while punching or while the physical struggle was going on, was still trying to grab the bicycle from him. If I could just make one final point, Cabrera recently did say that whether a defendant was subjected to custodial interrogation is a mixed question of law and fact, and there is record support here for the lower court's determinations that he was not subjected to that, and therefore this court should affirm on that basis as well. If there are no further questions, we ask that you affirm.
Thank you.
Just to put a finer point on the issue of harmless error, the question at trial being that the defense conceded a larceny, asked for the charge on petty larceny, and conceded that there was an assault, the only question was mens rea, and that was what the court charged itself with, was whether the force was used to take the bike or to retain the bike, or whether the force was separate. So the only issue here for the fact finder is the purpose of the force, and that's exactly what the statement spoke to.
What do you say about the fact that he says the video shows a number of blows thereafter?
A number of blows thereafter?
That he admits to one, but there's a video showing many more.
Right, but I think the point on harmless error is that what the video does not show clearly is any effort to try to retain the bike during the punches. So whether there be one punch or multiple punches, of course there were multiple here, the question for the fact finder, given what the parties had conceded, was the purpose of it.
If we saw in that video something that, looked like a person taking a bike and moving out of frame with it, and then another person jumping into action and going after them, and you see a tussle, would it be your argument that it's not fair to assume that that was a struggle for retention of the bike?
If there was a tussle, and I'm sorry, as to harmless error?
Yeah, whether that's sufficient evidence to overcome, the problem with the statement. If we exclude the statement, would that be enough?
I'm sorry, Your Honor. Do you mind repeating? I'm sorry.
So I'm just wondering if you see a struggle, you said that you can't really see a punch, but if you see them struggling over a bike.
Oh, no, to clarify, you can certainly see the punch. You can see multiple punches. The punches were numerous and violent. What you cannot see is the issue that was being disputed, which was the reason for the punch. Whether the punch, to be sufficient for a robbery conviction, was used to retain the bicycle to complete the taking, to be a forcible taking.
Can you make that inference from what you're seeing in the video? Or is that just...
No, because it's from a very distant vantage point, numerous feet up in the air, very far away, and it's also blurry, which the prosecutor admitted at trial.
Okay, but we know who those people are in the picture, right?
Yes, we know who they are, but they don't have facial features, for example. It's very, very, very far up. So the only question that the video doesn't answer is what the force was used for. And where the defense is arguing, yes, we punched him, the defense punched the complainant, but it was not to retain the bike, it was because the complainant had jumped on the defendant to get his bike back, and the defendant was so shocked by this that he started pummeling him, or whether, hence a retaliatory assault, rather than an assault for the purposes of a taking.
Thank you.
Thank you, Your Honors.